Joining us now on 710 KURV from TexasDefenseFirm.com is Jeremy Rosenthal, and we're taking a look at some of the SCOTUS rulings that came out this week, and they are dropping some bangers. It's always the best of when these guys come out and make some rulings. Let's start off with the parental rights, the LGBTQ ruling that they put out. What did they say and why?
Right. Essentially, what this one was about was that parents sued their school district because they felt like their children were being exposed to material that was supposedly LGBTQ friendly or that contained some LGBTQ overtones. And the parents sued, and their theory was that it infringes on their religious liberties. Obviously, you've got a lot of hot topic issues. Everybody gets really worked up when we start talking about schools and things like this and material that kids are reviewing. It's a bit of an interesting theory to say that violates religious liberties. The Supreme Court, the composition of it being 6-3 conservative. You would think that they'd be kind of playing with favorable numbers, and as it turns out, they were correct. So the court did say that they could exempt their children from this type of curriculum based on religious liberties as the theory. The alternative would have been probably a First Amendment challenge, which is a little harder, you would think, to sustain.
Is the spirit of the law here parents can do whatever they want concerning their kids? I know that's kind of reductive,
so.
But yeah.
I think that's kind of where the Supreme Court is sort of headed, right? They've done I think a handful of cases that are sort of similar to this, where they've just sort of inched and nodded towards more parental flexibility, more parental ability. Obviously, again, anytime you talk about schools and the curriculum and what kids are learning, gets folks pretty worked up. You couldn't when you try to tell the school, look, just by having this type of material out there that's wrong, then the flip argument there is, well, that's censorship, and this may have some literary merit. Or this may be age appropriate, and it may be curriculum appropriate, and you could get academics who say that's accurate. So what's your retort then? You could, in this instance, they said, well, it's our faith, and so we're not trying to take this away from everybody. We just don't want our kids exposed to it. And again, yeah, that's the Supreme Court found merit in that line of thinking.
Jeremy Rosenthal is an attorney from the DFW area, joining us on 710 KURV, and check out TexasDefenseFirm.com. We're taking a look at some of the SCOTUS rulings that came out. One of them, is this one a 2-in-1, really? The one on birthright citizenship and the limitation to district judges' ability to issue a nationwide injunction?
This is the big one. This is the big headliner for all of them. What they did was they essentially said that a federal judge cannot just block an executive order essentially nationwide. That they can do it for the people who have who brought the suit, but they can't necessarily do it everywhere. The argument, so the birthright citizenship argument didn't actually come up. And the Trump administration didn't try to argue that birthright citizenship was legal. What they tried to argue was that you can't block it everywhere. And we may not see the full question come back to the Supreme Court. But it is pretty groundbreaking, because now if you have an executive order, a judge cannot block it except for the people who have sought to enjoin it. In other words, if you think about it like this, think about take a Second Amendment argument, right? If, for instance, we were to ban, if the president were to say, okay, from now on, I consider all weapons to be contraband, and I'm going to order law enforcement to go seize all this contraband. Well, you've got a Second Amendment problem there, right? And who can stop it? Who could prevent law enforcement from doing that? Well, you could go to court and then get an injunction, but now what that's saying is everybody individually would have to sue, or big groups would have to sue, and only if you're a member of that group would you be able to really stand in front of that. In this instance, you've got a lot of people who are potentially subject to that, to the birthright citizenship. That is, their parents were not here necessarily lawfully, but they were born here, and those people, unless they directly sue the federal government, are they subject to their 14th Amendment's rights being violated? That's a really, really complicated factual scenario, but that's kind of what the Supreme Court waded through.
Without taking a side, because I just want to ask the question outright if the nationwide injunctions were getting out of hand, but I don't. That's a loaded question. Is it more like, has it always been like that, using an injunction like that, or has it just been up until recently?
It's been that way for some time, but it's been more and more and more common. Over the last 20 years, it's been just a lot more common. That's a function of gridlock in Congress, right? When Congress can't pass laws, or they don't pass laws, or they can't even decide to take a bathroom break, they don't have enough votes to go do that. When Congress can't get along, well, we got to have an immigration policy, don't we? And so we've got to. So you've had the chief executive essentially legislating by executive order now for the past 15 or 20 years. That goes for George W. Bush. That goes for Barack Obama. That goes for Joe Biden, and it goes for Donald Trump. All of them have used the executive orders increasingly and increasingly and increasingly. And so that's why you're seeing all these federal judges that have been blocking things, because people come to them and say, Judge, this is unconstitutional. And the judge says, I agree, I'm going to block it nationwide. It happened to Joe Biden last year with his federal student loans forgiveness. And it's obviously happened to Donald Trump a lot in his first 100 or so days. But now that that's going to be peeled back, we'll see if the president gets a lot more bullish with executive orders.
Jeremy Rosenthal is an attorney. Check him out at TexasDefenseFirm.com. He joins us now on 710 KURV. And Davey, I'll let you pick the last one. We're looking for either the Obamacare requirement or the porn law. Which one do you want to talk about, Davey? I'll let you pick.
Well, the porn law is Texas. So, yeah. So
did you get to look at the exhibits?
What's that?
Did you get to look at the exhibits?
No. Right. Yeah. That's a good question. Maybe. Yeah. You go and all right. We got to do a real deep dive here. Pardon the pun. Yeah. I didn't. Yeah. Okay. Anyway, let's get this ship right.
I derailed it.
So. Yeah. Texas passed a bill that Texas passed a law that says that pornographic websites have to do age verifications that are pretty extensive, and that means entering in valid photo IDs and functionally it's when I'm picking a jury, if I ask the sweet old lady in the third row, ma'am, what's the number one business on the internet? Even she knows it's porn.
Right.
So it's a lot of money. It's a big industry, and Texas said we're going to require. We want to protect children. We don't want children going to those sites. So we're going to make it really hard for people to. We want to make it. We want to make sure that only adults are accessing this material. Obviously, there was a challenge to that, and the Supreme Court said that no, it doesn't violate the First Amendment to require that type of identification. So yes, Texas law is it's valid and it's good, and anybody looking to access those types of sites are going to have they're going to have to pass whatever tests that the
oh man, and then enforcement's another question, right, Jeremy? That's going to be a big question. How do you enforce that? Hey, but that's a question for another day. I appreciate your time and hanging out with us this afternoon. That's Jeremy Rosenthal, TexasDefenseFirm.com, joining us on News Talk 710 KURV.